Now we have Judge Ballard and Judge VanMeter. They're both here in the 11th Family Court Circuit in Kanawha County. And we're going to talk about what judges like to see in recommendations from guardians, the do's and the don'ts for purposes of providing information to the court. So let me get the mic back up here. You know, we're having some issues hearing, so when you want to ask a question and you get recognized, if you can stand up so that we can hear you, that would be greatly appreciated. But I want everyone to know we're back on track, so we're not going to run late, and that's a big plus. So let's start it out with the judges talking about what they're seeing in their courtroom and the type of guardian cases that they're appointing you in.
Good morning. How's everybody today? I'm Ken Ballard, as Lisa just told everybody. Well, the way we appoint cases has kind of changed a little bit, but anymore, obviously both parties have to be indigent, and usually what we're looking for is if there's some sort of issue with the family, particularly with pro se litigants, because they don't know the information that we need. They come in and they just basically say everything, and usually all at once. And trying to decipher what's going on in the family is very difficult. So it's very important in those type of cases that we can appoint somebody who can be sort of the boots on the ground, because you know, people will say a lot of stuff, but that doesn't necessarily mean it's all true, as everyone knows. So a lot of stuff that we're looking for is, you know, you're sort of the, like I said, the boots on the ground, but you're sort of the person that gathers the information, the documents that we need, you know, the school records, sometimes medical records, sometimes treatment records, CPS records. We need those. We need those. So, and a lot of times what we need for them is, sometimes we need them, and sometimes if there's sensitive information there, we need to be told that they need to be sealed so people can't see them. But we also need sometimes for them to be summarized, so we're not looking through 110 pages of medical documents or something like that. Those need to be summarized so that we can quickly get through them and get the important parts. So we rely upon you to do those things for us, because that makes our job easier. It also causes us to have a better result, I think, for the children that we're trying to protect here. So make sure that you are getting as much documents as possible. You don't have to get all of them, but to get as many as possible, to try to, so we can vouch the record. So the first thing probably we need to do is, when you get the information, is go ahead and make an appointment to get out there as quickly as possible to meet your client and to get the information with regards to who you need to talk to. One of the things as a judge that frustrates us more than anything is that when we come to court and we get there and then it's like, well, I haven't talked to so-and-so, or I haven't been able to track down this, and there's constant delays. Sometimes they're not your fault, and we understand that. And we understand that it's not always everyone's fault, the guardian ad litem's fault, but it's just frustrating for us to try to get to an end result when there's a lot of delays, and if it's constant in a particular case, or a particular guardian ad litem. If you have a history of constantly delaying things, then we take notice of that too. So try to be cautious of that. Try to be, when you get the stuff, try to get on it as quickly as possible. Meet your client and try to start getting the information, gathering the information, so that when we're ready for court, you're ready, and we can try to get where we need to go. It's also important to meet all the caretakers, I think, as well. You know, a lot of cases, you know, there's a lot of there's a lot of grandparent involvement in a lot of cases, as everyone knows. The drug epidemic, there's a lot of grandparents filling voids. So you need to reach out to those people as well. And it's vital important also to talk to the teachers. Teachers know more information than probably anybody. So it's, if you can talk to their teachers, that is they have a lot of information, because kids just say things. And they may not know what they're saying, but you know, teachers take notice and they notice things, and they can give you a lot of information about their interactions with the family, how the kids dressed, you know, whether they're prepared for school, whether they show up late for school constantly, you know, what days are they showing up late for school? Because, you know, sometimes is that dad's day, is that mom's day? You know, whose day is it that they're showing up late and unprepared and disheveled, and not clean? So those are all things that you should take a look at. So you talk for a while. I'm tired of talking.
You tired of talking? Okay, I know that.
Okay.
Okay, thank you. Of course, and I'm Judge VanMeter. I'm also on the bench. I sit next door to Mr. Ballard here, Judge Ballard in Kanawha counties. And taking off on part of what he said is it's sometimes you can't always get to everybody. We know that. Sometimes people won't answer the phone, or they won't set up an appointment with you. If it's one of the parents that won't cooperate, then you move on, and you put that in your report, and that's obviously going to go along with your recommendation is, one parent wouldn't cooperate with me. Well, you know good darn well, if that parent's not cooperating with you, they don't want to talk to you. They don't want you to see their house. So there's some reason they don't want to talk to you and avoid you, and that's going to play into your recommendations as well. Don't not do the rest of your investigation because you couldn't talk to mom. Continue on and tell us. Tell us in the report that I tried to call mom on this day, this day, this day. She wouldn't call me back. All of her numbers are disconnected. So again, that's not your fault. You've done the best you can, and that's all we can ask you to do as guardians, and the best you can do for your kids. One of the things that we obviously would like to see is, because we can't do, is the home visits. So please don't drive by and say the house looks fine. I saw that in a CPS report recently that they drove by the house, and then one of the allegations was that the house was a disaster. They drove by, house was fine. Please don't just drive by the house. If you need, we want to know if one of the issues is the home. Now, not every case of home is an issue. So, for instance, if it's really not, if that's not your issue and you have to go, that's okay too, but on a lot of the cases it is. The home's not clean, there's no food, there's no heat, there's no utilities. And one interesting thing is, and I learned this from somebody else, when you go to the home, turn on the water and see if they actually have water. If it looks like a place that might not have water. Because that was one of the things, or ask to see the utility bills and see if they actually have the utilities on and they're paying them. Because I actually got caught up in one of those as well that, they didn't have any water, but I didn't know it. Because I was there and it looked like they had water. Well, you didn't turn on the thing. And I've opened the refrigerator. Do they have any food? Open the cabinets. Do they have anything to eat? And just see what it is at the home. See how the home is. And that's one of the things that obviously we can't go do that we rely on you all to do is the home visit. But again, if they're dodging you, there's a reason they're dodging you. So please make note of that in your report, okay? Here's a big one, and I think we've already had this a lot, is the parents, because you've already talked to the parents and the caretakers. Well, they have a laundry list of people they want you to talk to. They give you a list of 25 people that they want you to talk to. Okay, you don't have to talk to all 25 people. See who's important on that list that is going to give you information. If mom tells you to talk to all of her brothers and all of her sisters and her mom and dad, you're probably not going to have to, because those people are going to be biased towards that person. You want to talk to the other people, maybe who have some independent knowledge of what's going on as well. And some of the other interviews are the therapists, if they have therapists, schools, like we already said, the principals, the teachers. Those are invaluable information. What gets to be the problem is when it's a child that's not school age. They don't go to school. And there's no other eyes on the child. You've got no professional to talk to. So that's one you have to go to the home and try to get as much independent information as you can from other people. There's also, don't be afraid to make recommendations regarding some other treatment for the child. If you think the child needs counseling, if the child, maybe the child's going to the school counselor, but maybe the child really needs counseling because of some issues, put that in your report as well. It's okay, you're out there, you're talking to them. If you think there's some other treatments this child might need, go ahead and put it in your report. Let us know, because that's stuff that we can order as well. And of course, and one of the things you also is when the child tells you what they want, or the child tells you information. one of the biggest things, and I think we've all run into this, is how do I tell the judge without jeopardizing the child's safety? So there may be things that you don't write in the written report that you were able to tell the judge at some point in time in court, but it's not in writing because you don't, and that way at that point in time the judge can admonish the people that there better not be any retribution to the child because of what you just said, or what the child said, what the child told you. And that's always one of the fears, is that there will be some retribution to the child on what they've said. So always be aware of that you've got to get the information to the judge can make a decision, but always be aware of it. Lisa wants to jump in.
Let me just say that if this is a situation where the child has provided you some type of information.
Can't hear you.
If this is a situation where the child has provided you some type of information and you believe that the court needs to know this information, and there could be some retribution by the parent that is being talked about, probably the better way to get this information to the court is through some either separate motion or pleading that you ask to be sealed, or some recommendation to the court that they actually interview the child. And that way, the court can go back in their chambers, interview the child, hear the information that they need, without you blurting it out on the witness stand, and then the court hoping that the child doesn't see any recourse from the parent. So, but I mean, you need to be very, very careful on if it's going to be something that is detrimental to a parent that is being brought to your attention by a child.
There is a provision in the rules
Yes.
that address exactly what you're talking about.
Right.
And the guardian files a motion to seal a certain portion of the report. They send that report to the judge.
Right.
The judge determines whether to share it with, and most of the time does share it with the counsel for the parents, but tells them they're not allowed to share it.
Right, and there is a rule that we have, and actually I wrote that rule, so.
Aren't you glad I remember?
Yes, I was gone for a year and a half. For some of you all, we saw each other 2 years ago. I was gone for a year and a half, and now I'm back. And so, and please, I know you may be questioning my intelligence, but it's been a great move for me. But so in that year and a half that I was gone, I really tried to erase, a lot of my knowledge of what I did while I was at the court for the last 12 years. And as I told all the family court judges, I found this zen kind of place that I didn't have before. I was pretty wired and high-strung, and I've tried to be a little more relaxed, and in the process, I kind of erased some things. So, but anyway, just again, be very careful when dealing with sensitive information that can harm a child, because believe me, even though you're told not to, and even though we tell counsel not to share this with their client, somehow or another this information can get back to the parents and kids can suffer the consequences.
I'm going to go first.
I was just going to ask about redacting certain portions that you give to the parent, give the
Right,
judge.
and you can do that, but you let the court determine what portions are going to be redacted before it's handed out to the parents. That means you got to get your
That means you've got to get your report in early. You can't be at the last minute. And, that's, when I get complaints from parents, it's because they don't get to see what you're doing before they walk through that door. And so they have no defense to what is written in that report. And so those are the kind of complaints I get from parents. And the only other thing that really bothers me is that when we listen to kids, and this typically is in abuse and neglect cases, where they talk about they never talked to this attorney that was supposedly their guardian. That bothers me more than anything else that you all do. That we have kids saying, I never met this person. I saw them 10 minutes before they walked into the courtroom to address the judge in my abuse and neglect case. That's not acceptable at all from attorneys. And if you're going to practice that way, then this is not the business you need to be in. So.
Well, I think we got into the written report, and the thing that we need, I stress more than anything is that the report is turned in timely. Don't wait till last minute to turn it in, because if there's an attorney, they're always going to object. They say, well, I didn't receive it. In my courtroom, when I have an objection that is not timely turned in, I automatically continue. I mean, it's not even, we have a continuance right there, because there's no way to correct it. And so that's their way of saying, well, I'm going to object, but we can still go forward. It's like, well, you can't. I mean, I get they're trying to hedge their bet there. If they like your report, then okay, no big deal. If I don't like the report, I'm objecting because I didn't get it in time. So if there's an objection that wasn't turned in on time, then it's an automatic continuance. So getting them on time. If there's information that comes in after it's written, then just submit a supplemental on the day of the hearing, and that this is information that I've acquired since I've read the report. So do the report to all the information that you have. And if you have to supplement, then we'll supplement. We can deal with the supplemental information. If there's an objection to it, we'll just depend on whether it's how important it is, and we can deal with that. But getting it written, listen, I know a lot of you do great work, and we don't need a 100-page report. Try to keep it simple, but get information that all needs to be in the report, but it doesn't need to be long. Get what needs to be in there, and make sure you document who you talk to. That's important. If one of like Judge VanMeter said, if someone's avoiding you or not talking to you, put in there how many times you talk to them, or try to communicate with them on what dates. Be very specific, because I guarantee you, what's going to happen is like, well, the person's going to, oh, well, they never called me, or they never talked to me, they never did this, and so be specific. This is when I called. This is exactly when I called, and this is the number I used. And so normally that breaks down that argument. It's like, well, they never contacted me. Just document it just to cover your own self. But don't be afraid to make recommendations, because we want them. That doesn't necessarily mean that we'll follow them, but it's important to get someone else's input with regards to you're there. You're actually there. You're actually in their house, or you're at the school, you're talking, you're hearing stuff from people. So it's important to get your perspective from your client's perspective with regards to what they would like to see happen. And so those things are important. That may not necessarily be what we do, but a lot of times it is what we do. So don't be afraid to make those recommendations, and be prepared to defend them. And that's where the documentation comes in. Be ready for opposing counsel or the parents' counsel who may feel like they're not getting what they want to cross-examine you and kind of rig you over the coals a little bit. But don't be afraid to defend the position, and don't wait. Just go with it.
Judge Ballard, do you mind to speak on who you think the written report should be sent to beforehand? Like, for instance, I don't know, a lot of us all have pro se. If there's attorneys, I understand sending it to the attorneys. But could you speak on whether the guardian ad litem should send it to the parents before the hearing?
Absolutely. It goes to everybody.
Okay.
That's my position. It should go to, if they don't have counsel, then it should go to the parties.
Even if there might be a concern, they might share it with the kids.
Yeah.
Yeah, well.
It's tough. It's a tough situation, but I think if it's something that's going to be detrimental to the child, it's going to be shared, then I think it should be handled just like Lisa had indicated. Information should be either, I've had situations where guardian ad litems before have given me 2 guardian ad litem reports. One is actually redacted with the stuff in it that they think is sensitive, and then they provide it to me and say, well, this one has the stuff that And then they let me make the decision whether or not the information in there should be provided to them after the fact. So I think if you're unsure whether or not that information should be, then I would err on the side of caution and not include it, and then let the judge make that decision. That would be my position if you were guarding that money for me. I would rather you err on the side of not providing something that could be detrimental, and then deal with it through the other process of whether or not it should be disclosed or sealed or have a protective order or something along those lines.
When you're talking about, are you talking about
When somebody's appointing you and you can't get to them, you talk about one of the parents that you're trying to get to one of the parents, and then the parent's going to come in and say they never met with me. Is that what you're talking about?
Well, I was talking about that earlier, but I think what we're talking about is whether or not she was asking, Judge VanMeter was asking whether or not we should provide the report to her.
Right, but you said something about document. Have any of you guys filed like a motion to have a hearing to address the fact that you can't get a meeting with the parent? So then everybody has to come there. You see the parent, and you address the fact that they're avoiding.
Yeah, I mean, that would be one way to do it. I'm of the opinion if they can't participate in the investigation, and they're not really that enthused about participating in the other group, the part of the child's life. So, I mean, it's a strong indication that if they can't get their act together in this short window when someone is reviewing their conduct, then what's their conduct going to be when there's no review of them anymore? It's going to be the same, if not worse. So, if they can't get their act together during the short window, then that's probably a good indication that maybe their time should be limited or even supervised.
All right, so, well, one of the things, and that's talking about recommendations, and I've had this come up as well. If you truly, when you're doing this investigation, don't recommend the child go to one of the parents because that's the least evil. I mean, you can make a recommendation to the judge that nobody in this case should have this child. It's okay. We can deal with that. But don't simply say, because you didn't know. I think I don't know how many people know, because I don't know how often it happens. I think I'm the only one who really does it much in Kanawha County. But
Easy there.
I know, it's okay, Judge Ballard. Calm down now, it's all right. I will order the child taken immediately by CPS. And I've done that. I've done it on more than one occasion. And it kind of throws people from the loop. And I don't know if you as guardians all know that we can do that. And it's okay. If you find that nobody is appropriate, tell me. Tell Judge that. Tell your judge. Judge, these parents, neither one of them should have this child. Now, there may be a grandparent that would be appropriate. That's okay to say that. We don't think either of these parents should have this child. But maybe there's another appropriate family member, or maybe there's nobody that's appropriate. So, but let us know that. Don't simply say we should go to mom when really you're only saying that because dad is worse. Okay, so we can deal with that, so just know that. Also, and I don't know if that happens often in you can also, if you think the child is in danger for some reason, something's happened, mom has the child, dad's supposed to have visitation coming up, and these are pro se people who don't really, like I said, they don't know the system. Don't be afraid to file a motion for ex parte with the judge, on behalf of the child. The judge will hear it. Well, I guarantee you, we will hear those immediately. So if you think dad shouldn't have the child this coming weekend because something terrible's happened, file your motion. You're well within your rights to do so. Okay? Any questions on that? Okay. And one of the things that I don't think I've really done, but one of the things we can do is we can order the continued monitoring. So say the case is over, we can ask that you stay in the case for another 6 months, maybe do some drug screens, check in, and see how things are going, and report back to the court. And if things are going well, fine and dandy. If they're not, we can certainly convene another hearing upon your motion that things have not gone well. That question.
I do. Speaking of drug screens, how are we supposed to get those paid for? I mean, we're talking about indigent clients. Where?
If it's all a waiver, it's free.
Where?
Clerk's office.
No, I mean, where can they go to get it for free?
Well, I don't, in our, it depends on the county. I know our county, our probation department does it.
Right.
Or the day report can do
Some
it.
counties, they'll refuse to do it. So what are we supposed to do in those cases?
This is yours.
Yeah, this is yours.
Just so you know, it is in the probation policy, and it has been adopted by the West Virginia Supreme Court that the probation department has to do drug testing for the family court. They cannot refuse to do it. Probation is under the West Virginia Supreme Court, and if you're having trouble in a certain probation office in a certain county, you just need to let us know, and it'll be addressed.
Our judge issued an order that they don't have to do it. The circuit judge.
The circuit judge in your county issued that order that they do not have to do drug testing for family court. Well, I mean, that'll just be something that has to be addressed.
We want to know what to avoid. And then they can be tested. He's not going to make probation tests repeatedly without getting paid.
You know,
21st, I think the rule's probably the same as the 22nd.
I think in the 22nd, it's probation that says that family court doesn't have the authority to make them do the drug testing.
oh, okay, so we're talking about the 20, when we talk about 21st and 22nd, we're talking about the family court circuit or the circuit court?
That's circuit.
21st circuit, the judge issued
Okay.
a rule saying probation didn't have to do it unless they were paid.
Okay, well, you know, that'll just be something, you know, I mean,
Up here in Lewis are the same way. There's
well,
a circuit court order that says they don't have to do it unless they pay.
So, because we have that problem too. So my question is, if you have that problem, and, I mean, you need to get these people drug tested, is that something that we can pay for and get reimbursed for?
well, here's the thing, the whole, it costs like $9 to have it done by probation. That's all it costs. It comes out of the budget of the West Virginia Supreme Court. And so, I don't even know how to respond to this at this point, other than it's something that I'll look into and work with the probation division in order to try to fix. The other thing is, we can't force people to have waivers to pay for anything, and that is the law. So, you know, that's unfortunate that, you know, we're dealing with some of these issues. But, you know, I'm not sure why this is being, you know, why this has happened, but, you know, it's something that unless someone in the administrative office knows is going on, it's not something that we can address and try to resolve. Yes.
We're having a similar issue under the law. We can get criminal background reports.
Right.
But we can't get them. The judge is entering orders, the family court judge, and the prosecutor's office has advised that they will not allow any of the law enforcement to do that. In Lewis, Upshur, and Braxton, I can sometimes get them if somebody is nice to me at the state trooper's office, but otherwise, we can't get them.
Welcome back, Lisa.
You know, I thought I had gotten all of this resolved when I was here before, and each family court judge, county that is, has their own identification code in order to do background checks. Even the federal government has said that in child custody cases and in domestic violence, you can get criminal background checks for individuals.
The prosecutor actually sent an email to me and to the judge saying that we did not have the authority under federal law to get them, and that the judge can only get them in cases that involve severe domestic violence.
Oh, severe.
Yeah, I don't know what that is.
Right, none of us knows what that is.
Where in the code is that? With severe domestic
I
violence?
don't know.
Yeah.
But they
Well, there is a section in the trial court rules that talk about that you can have a guardian appointed in what they call severe domestic abuse. And that's something that that's something that is a new word, a new phrase, catch-all phrase for domestic violence. And at the time, I was on my way out, literally, and so that phrase has no definition. I don't even know what it is. So, but anyway, I mean, these are all things that we can look into and try to work with. I think a part of the problem too is that under Chapter 51(2)(a) of the Family Court's powers, it says that family court can get criminal background checks. The feds had told me, because I was fighting back and forth on how we can get criminal background checks, is that if our law provides that we can get criminal background checks, that they will then allow us to get criminal background checks when we need it. The problem is this: when you're dealing with domestic violence, you can get that quick check done, it's over with. When you're dealing with child custody, they want fingerprints. And the reason why they want fingerprints is that somewhere up north, somebody had a boyfriend living in their house. He gave his name, which was also the name of his father. So he didn't give like Junior, and he gave his father's Social Security number. They did the background check. Dad came back fine, boyfriend came back fine, and then the child gets, I think, sexually abused and murdered. And when they finally get to this actual boyfriend, he was a convicted child molester. And so from that point on, when you're dealing with child custody issues, they want those fingerprints so that they can determine who exactly they are dealing with. And so that was the case that was provided to me, and as all of you all know, anytime you have a bad situation, our legislators and things overreact, and we come up with a restriction that then creates a situation that, to address this horrible situation that happened, then creates other problems, because it takes even longer to get back criminal background checks when you're dealing with fingerprints. So that's how we got into all of this, and I can try to address all of this with your prosecutor and everyone, and I'll do it through the state police, because they will help me get through to your prosecutors. Yes.
While you're doing that, Denise's question about getting drug screens, I had that same problem in Randolph County. My client or the parent of my client was ordered to have regular drug screens, and the probation office wouldn't pay for it. They were making her pay $10 a screen. And then we had ordered supervised visitation, and she was also made to pay for that. There was no place to get supervised visitation that didn't charge her like $20 or $25.
What she said was that she's in a particular county, which I'm not going to mention it again, and not only did her client have to pay the $10 per drug test, but she also had to pay for whoever it was that was supervising her visitation. And is this someone who qualified for a waiver?
Yeah.
Well, again, these are all things that we're going to have to look
I just want you to put the
at.
supervised visitation on your list, right? Because I'm
Right.
saying to protect my client that the mother needed to have supervised visits, but then the mother isn't obviously going to get a recommendation for custody if she doesn't have any contact with the child. That's the only way she can contact the child, but she doesn't have the recommendation.
Right.
And the
Well,
judge ordered everything to be paid for her, but every agency that they looked at the order and they said, well, no, we don't have to do that.
well, just so you know, under the powers and administrative administrative functions of the family court. It's 512A7, subsection A4. And it says that the family court shall exercise any power or authority under Chapter 48, and it says, including but not limited to, and it goes to compel and supervise the production of evidence, including criminal background investigations, and it says when appropriate. So that's left in the discretion of the judge. So I just wanted to make sure that you all realize where the code section is. And it's in Chapter 49 that says that family court judges can provide that the children to the state custody. And that's after they make sure that there's no other family that can provide the care for the child. Then they can call in the state.
Yes.
Quick question on an unrelated topic. As guardian ad litem, we're supposed to determine what we think is in the best interest of the child or children. And this has come up primarily in an abuse and neglect case. The child is of sufficient age to form an intelligent opinion, 13, 14, whatever. And it's my belief as a guardian ad litem that they should be placed with one parent or the other, or a grandparent or whatever. But the child's wishes are diametrically opposed to that. They want to go with dad or mom, and I don't think it's in that child's best interest. What do we do in that context? Are we supposed to have an attorney appointed for the child?
Okay, you need to file a motion with the court, bring it to our attention so we can appoint another attorney.
Right.
So in family court, the child can have an attorney in fact as well?
Yes.
Yes.
And that's in the guidelines for
It happens rarely.
guardians.
It happens
It's
rarely.
It's
but-
also in your guidelines under child abuse and neglect.
Right.
You need to go to your guidelines and about everything you're supposed to be doing as a guardian for those children. And one of the things in there is when what's in the best interest of the child for the child is completely different than what the child wants. And at that point, and there's also a Supreme Court decision on this, and another attorney should be appointed to represent the child instead of the guardian. Because you're there to do what's in the best interest of the child. Now the child is fighting to do something that is not in their interest, and therefore needs an attorney to represent them
But
on
is
trial.
that attorney in addition to you as guardian?
Yes, yes it is.
Okay.
One more question.
So this may be a change then, but I know that Catherine Munster is always, whenever this has come up with the guardian ad litem trainings for abuse and neglect, she's always told us that because we have promised the child that we are their attorney, that we need to ask for another guardian to be appointed so that we can continue to advocate for the child, because we have attorney-client privilege with the child as their attorney. So has that been changed somehow?
Well, your duty as a guardian under family court is you have a duty to the court.
So it's opposite.
It's absolutely the opposite of child abuse and neglect.
Judge, may I make one thing about when we're talking about, excuse me, utility bills?
Yes.
Check them all, including the cable and the telephone. I have had emancipated children that I have been guardian of to call me when they are 18 years old and tell me that their credit score, that their credit report shows negative history because their loving parents put the water, the gas, the sewer, the phone, and the cable.
Right.
They can't get cable or a cell phone.
Right.
Because they don't have any, so
Did you guys hear what she said? She said that as guardians, we need to check to see who the utilities are, what name the utilities are in, because these kids are finding that when they age out or they become 18 and they're trying to get credit, that they can't get it. They have a negative credit report because their name was the name and social security number and everything associated with the utilities. And therefore, they get out into the world and have a horrible credit rating. So you need to be checking to see what, whose name the utilities are in. Lord, I would have
Thank you.
never
Yes,
thought.
What happens if the water gets turned off or the telephone gets turned off?
Yes.
Right. A lot of the utility companies, though, when something like that are happening, they're asking who all's still living in the home. And so, I know that that's happening. But anyway,
Is there a source for the fingerprint cards that we can use to do the criminal background checks?
the only, honestly, there is, but every bailiff, that the court has the ability to do the fingerprint cards. So if that's the situation you're in, if you're not in a domestic violence case and you're in just a regular D case, you can have the bailiff do the fingerprints of both of the parents in there so that you can do the criminal background checks. Okay?
Thank you all very much. We appreciate it.
Thank you.